Welcome, everyone. Thank you for joining us for our webcast on NASAA's FPR commentary, What Franchisors Need to Know Now. My name is Max Schott, and I am a principal at Plant Mooty's Minneapolis office, and I've had the pleasure of being with the firm and counseling franchisors and distributors for over 20 years.
And good morning or good afternoon, everyone, depending on where you're dialing in from today. My name is Diana Vilmenay, and I'm an attorney in Plant Mooty's DC office. I am celebrating my one-year anniversary with the firm next month, and I have been practicing franchise law for close to 9 years.
From the outset, we thought it would be helpful to give you an overview of what we plan to cover during our webcast. So first, we're going to provide you with some background regarding NASAA's FPR commentary and why we think franchisors should strongly consider complying with it now. You may have seen in the title of our webcast, the word now was underlined. If it had been up to me, it would have been in bold and all caps with exclamation points, but our marketing people said that was excessive. So just underline. So in any event, we're going to focus on, first of all, what we see are the top issues, and so those really relate to a number of subjects, the most important of which, and probably the most controversial, is the restrictions that relate to FPRs involving company-owned outlets. So we're going to spend a fair amount of time drilling down on that. We're also going to focus on some additional disclosure requirements and restrictions relating to averages and medians, top performers, and other subsets, closed outlets, and then managed outlets. And finally, we're going to focus on some limitations relating to the use of merged data, cost and expense data outside of an FPR, FPRs based on forecast projections and disclaimers. On the lower right side of your screen, there should be a Q&A box that you can use to submit questions during the webcast. And we'll do our best to either answer your questions either along the way or towards the end of our time together. And you should have received a copy of this PowerPoint and PDF, as well as a one-page supplement we're going to refer to. It's my understanding that went out in a reminder email yesterday. If you didn't get those, the information will still be most on the PowerPoint, and those will be available after the presentation. And finally, please, absolutely no multitasking during the webcast. We have technology that allows us to tell whether or not you're paying attention. Okay, I'm just kidding. We don't have that technology, but we're hoping to keep you engaged with our quality content and our charming voices, or at least our quality content. So with that, I'll turn it over to Diana.
Thank you, Max. A quick commercial break before we formally launch into our program. This year, Plant Mooty is hosting a series of webcasts on various topics of interest to the illustrious franchise community. For example, 2 weeks ago, our colleagues Liz Dillon and Erica Tokar presented a webcast on major topics to consider for the 2017 franchise registration and renewal season. The PowerPoint slides and the recording from that session are available online. We have also, however, pasted a link here to that recording so that you can take a look at it after this presentation is over. On Wednesday, March the 15th, our colleagues Danelle Karen and Julia Dayton-Klein are presenting a webcast on the FDA food and labeling requirements, which in sum requires all restaurants and food chains of a certain number of locations to post nutrition labels for their standard menu items. That's coming out later this year. This webcast next month is going to be really informative, so please look out for the email blast invitation from our GPM events team within the next week or so. Okay, so now that we have the logistics out of the way, let's talk a little bit about the basics. Our guests on the line have a wide range of experience on financial performance representations, so please bear with us a little as we spend a minute or three to give some background on the FPR commentary. So the FTC franchise rule permits a franchisor to provide information about the actual or potential financial performance of its franchise and company-owned outlets if there is a reasonable basis for the information, written support for the FPR, and if the information is included in the FDD. We may take pains today to emphasize the phrase reasonable basis, and the reason we're doing that today is because reasonable basis is the crux of this entire discussion. This is a fact-specific inquiry that will depend on the content of each FPR. You'll need to ask yourself, does the written substantiation actually support the representation as the FPR is likely to be understood by a reasonable prospective franchisee? According to the commentary, the FPR must be based on the sort of factual information that a prudent business person would rely on to make an investment decision. So why are we talking about this now when the most recent iteration of the franchise rule was implemented 10 years ago? It's really quite simple, folks. More and more franchisors are including FPRs in item 19 of their FDD. Recent stats show that at least 50% of franchisors are using FPRs in item 19, and there is a wide variety in the types of data franchise attorneys are using as the written substantiation for the FPR. So the answer to the question is likely due to an outgrowth of concern from state examiners and franchise attorneys regarding item 19 issues. Specifically, state examiners agreed that it would be helpful to have some additional clarification about how franchisors should make an FPR in their disclosure documents. And that's where NASAA, which stands for the North American Securities Administrators Organization, stepped in. NASAA, which is an organization that's devoted, frankly, to investor protection, has a franchise and business opportunity project group that serves to propose model laws and commentaries and other initiatives regarding franchise disclosure to help protect investors, and the other aim is to help promote uniformity among state franchise regulators and the FTC. So NASAA recognized that there was very little guidance as to what constitutes a reasonable basis for making and substantiating an FPR.
So how did we get to where we are now? Well, several years ago, NASAA's Franchise and Business Opportunity Project Group began work on a draft FPR commentary. And Dale Cantone chaired that group, and many of you know him. He's Assistant Attorney General and Deputy Securities Commissioner for the state of Maryland. And so after some work, on October 15th, NASAA released its initial proposed FPR commentary and request for comments. And like prior commentaries, it follows a question-answer format. And during the first comment period, NASAA received comments from 17 different commenters, 14 with public comments, and 3 with informal comments. And a task force made up of state and federal regulators as well as franchisor and franchisee attorneys helped NASAA analyze all of the comments. And to their credit, they really did go through and review and consider every comment, and some of them were taken into account and others were not in the future draft. But then almost a year later, on September 14th, 2016, NASAA released its current proposed FPR commentary and again a request for comments. This time, NASAA received only 5 public comments, and all of the public comments are posted on NASAA's website. So if you want to go and take a look at the different comments, you're free to do so. And Great Plant Mooty submitted comments during both comment periods on issues we thought were important to franchisors. And I participated in an FPR program with Dale Cantone and Eric Karp at the last ABA forum in November. And during that program, Dale indicated that the current proposed FPR commentary is likely and close to its final form. Any additional substantive changes would require a third comment period, and I get the sense that NASA is not excited with that proposition. However, in response to one of our comments, Dale explained that NASA will likely add language clarifying that the FPR commentary should not be applied to FPRs retroactively, which is good news. So, for example, if your prior FPR probably didn't average and medians, or maybe didn't contain the exact admonition, and so they're going to clarify the fact that you shouldn't be able to go back and say that those FPRs were defective because they didn't meet some of the technical criteria of the current proposed commentary. So according to Dale, NASA is not expected to adopt the final version of the commentary until at least September of this year or even later. And then even when it is adopted, there's going to be a phase-in period before it becomes effective. So specifically, the effective date was going to be the later of 180 days after the date of NASAA's adoption, or 120 days after the franchisor's next fiscal year end if it has an effective FDD as of the adoption date. The FPR commentary guidance applies to FDDs updated after the effective date. So it appears from this language that the final version is not going to become effective for any franchisor until at least sometime in 2018. But even when a franchisor is going to be, or when a franchisor must comply with the FPR commentary after it becomes effective, however, is somewhat unclear. For example, does the second sentence mean that if a franchisor's item 19 does not comply with the FPR commentary as of the effective date, the franchisor has until the next time it updates its FDD to comply? And if that's the case, what constitutes an update? Is it the next quarterly update under the FTC franchise rule? Is it the next annual update? Is it the next amendment or renewal? So this is an area I think there is going to need to be some clarification, and so hopefully NASA will provide some guidance between now and then. But at least as far as an effective date, most likely that's going to be well into 2018 for most franchisors.
So, Max, even though it looks like the FPR commentary isn't really going to be completely effective until 2018, what we need to know now is that during the current renewal season, state franchise examiners may look to the proposed commentary for guidance to determine whether a franchisor has a reasonable basis for the FPRs it's making in item 19. For example, we do know that Maryland is one state that has indicated it will use the commentary as a guide. So let's talk about some other potential impacts here for the 2017 renewal filing season. If you take a look, if you recall, the FTC issued amended franchise rule FAQ 38 back in July of 2014. What that FAQ ultimately served to do was to give extraterritorial effect to one state examiner's comments on item 19. In sum, it suggests that franchisors should adopt those revisions it makes to item 19 at the request of the examiner and incorporate those changes in each version of the FDD to the extent it has one for different states. If the franchisor fails to do so, FAQ 38 seems to indicate that it will call into question whether the FPR meets the requirements of the franchise rule and also potentially expose the franchisor to more scrutiny by state examiners. Another interesting point is that the FAQ still acknowledges that whether a franchisor uses the same FPR in each state does not change the franchisor's burden to substantiate those claims. Also consider that FAQ 38 could be read to suggest that revisions to item 19 are material and would in certain instances require a formal amendment in registration states where an application has already been approved. So imagine this interpretation would lead to a very expensive and potentially time-consuming process.
Right, and it's one of those things where ultimately FAQ 38 leaves it to the discretion of the franchisor and their counsel to determine what a reasonable basis is. But I don't know that you want to find yourself in a position arguing in court that your FPR had a reasonable basis despite the fact that a couple of states found that it didn't have a reasonable basis. And so this is why we think it's important to look at this now, is because if you've got one state like a Maryland or some other registration state that comments on your FPR during this renewal season, you know, you would want to think long and hard whether you need to make that same change to your FPR for all of the states.
Exactly.
And so that's really why we are talking about this today.
So let's talk about the top issues to review before finalizing your FPRs for 2017. One item, the commentary defines the following terms used therein, including averages and medians, company-owned outlets, operational franchise outlets. It also defines key financial terms such as gross profits, gross sales, and net profits. On the handout that we referred you to, this, as Max mentioned earlier, it was a supplement that he used with Dale and Eric in Miami in November. There is a helpful chart at the top to which summarizes and defines the key financial terms as they're defined in the actual FPR commentary. So, for example, if you look at the chart, if you want to figure out what the defined term gross sales means, looking all the way in the top row to the right, gross sales is defined as total revenue minus sales tax, discounts, allowances, and returns. So those are that's just the way that the FPR commentary defines these terms. You should note that an important aspect of the commentary is that franchisors must define their own terms. So if you're making FPRs based on gross sales or net profits, in your FPR, you must define how those terms are calculated.
And now we've reached a point discussing FPRs based on company-owned outlets alone. And this was by far the most controversial section of the FPR commentary. And in particular, the initial proposed commentary provided that a franchisor without operational franchises cannot make a gross profit or net profit FPR based on company-owned outlet data alone. And all 11 comments NASAA received about this item objected to this prohibition. So thankfully, the comments NASAA received have made a difference in this area. And as we'll further describe, the current proposed FPR commentary reflects certain concessions, and NASAA should be commended for keeping an open mind and seriously considering comments it received, especially in this area. And so I'm going to refer to the handout again and the chart that is in the lower half of the handout or the supplement that we provided. And what we tried to do is organize in a helpful or an easy to understand way kind of the 4 possible scenarios when a franchisor wants to make an FPR based on company-owned outlets alone. So if you bear with me, you could make an FPR either based on gross sales or gross profit or net profit based on those company-owned outlets alone. And then the scenario is, do you have only company-owned outlets or do you have both operational franchise and company-owned outlets? And so the slides that we're going to go through now are going to focus on each of those quadrants in the chart. So we're going to start in quadrant 2. And so the question is, if a franchisor has both company-owned and operational franchise outlets, can it make a gross sales FPR on company-owned outlets alone? And the answer is no, that you can't. And the reason you can't is because a franchisor has no reasonable basis for making a gross sales FPR based solely on company-owned outlet data if it has at least one operational franchise outlet. So what is an operational franchise outlet? Well, essentially what that means is you've got at least one location or outlet under a franchise agreement that's not a company-owned or affiliate-owned outlet, and it's been operational for one full year or one full season, depending on the industry. And in assessing whether you have an operational franchise outlet, you look to the last fiscal year end. So moving from the second quartile back to the first quartile, what if a franchisor has company-owned outlets only and no operational franchise outlets? Can it make a gross sales FPR based on company-owned outlets alone? And the answer is yes. A franchisor can do that, but it has to have a reasonable basis for the FPR, and then it has to disclose material, financial, and operational characteristics of the company-owned outlets reasonably anticipated to differ material from future operational franchise outlets. And so that seems fairly reasonable, and it's probably consistent with what most franchisors do now. So I see potential factors as being, for example, these would be the types of things that may cause a franchise outlet to have different sales than a company-owned outlet. Things like name recognition in the market, length of time in business, the level of competition, local market for the products or services offered, the size of the outlet, demographics, anything that may cause the franchisee sales to be different than the company-owned outlets. And so that can be done in a footnote, and again, I think probably most franchisors likely have that type of information in their FPRs already. Moving now down the chart, if you will, we're going to address gross profit or net profit FPRs. And so the question again is, if a franchisor wants to base an FPR on company-owned outlets alone, is that permitted? And this was actually probably the biggest concession in the current proposed FPR commentary. It initially did not allow an FPR of this type if the franchisor did not have operational franchise outlets. The reason being, so the franchisor has company-owned outlets only, but no operational franchise outlets. And the point NASAA was making is that if you don't have any franchise outlets, how can you tell what their expenses are going to be, and how can you tell whether those expenses are going to be different than the company-owned outlets? Well, the compromise they reached is you can do an FPR as long as it has a reasonable basis. You disclose the actual costs incurred by the company-owned outlets, but then you now take it a step further and you provide supplemental disclosure or adjustments to reflect actual and reasonably expected material, financial, and operational differences between company-owned outlets and operational franchise outlets. What this means is that you have to supplement or adjust an FPR to take into account additional or higher fees that a franchisee will pay as compared to a company-owned outlet, or to reflect where a franchisee will pay more for goods or services. And the disclosure of any differences or potential differences between company-owned outlets and franchised outlets must be clearly presented in the same format as the rest of the FPR. So for example, if it's in a table, then the supplemental disclosure or adjustments also have to appear in a table. So what does this mean from a practical perspective? So here's what I think it means. If you take for an FPR that's based on the net profits of your 10 company-owned locations, let's say, and you take it all the way down to net profits, what I think it means is you have to add supplemental disclosures. So you would have to go into that table, that FPR you have in your item 19, and you'd have to add a line for things like royalty payments that the company-owned outlets aren't making. You'd have to add a line for ad fund payments that a company-owned outlet is potentially not making. So essentially adding to the table any line item that a franchisee will pay that a company-owned outlet didn't have to pay. And then in addition to that, you need to make adjustments. So for example, if there's something on there about buying inventory or buying equipment or supplies, and the franchisor or the company-owned locations can get those items for a much lower price than the franchisees, then you'd actually have to adjust those numbers to account for that fact. Or if labor costs are less because a company-owned outlet is able to share managers, or if they don't have to incur the cost of training, for example, or the same level of cost for training, that would have to be adjusted. So ultimately then, once you add in those supplemental costs as well as adjustments, it is going to adjust the net profit number then of the company-owned locations. And that's going to be reflective then of what you think a prospective franchisee would, their expenses, what their net profit could potentially be. So now we're moving to the fourth quadrant, and really the only difference there is that, again, you're going to do an FPR that's based on net profit or gross profit of company-owned outlets, but in this case now you have both company-owned and franchise outlets. And so the only difference between the two is you also have to disclose gross sales data from the operational franchise outlets. So in sum, provided a franchisor satisfies the requirements, it can make FPRs based on company-owned outlets alone. The one exception being that if a franchisor cannot make a gross sales FPR based on company-owned outlets alone, if it has operational franchise outlets.
All right. So let's move the discussion along and talk about averages and medians. You cannot have one without the other. So whenever a franchisor discloses an average of numbers in an FPR, it must disclose the median of those numbers and vice versa. The rationale there is that including one without the other may be misleading, even if the calculation is accurate. For example, the existence of outliers can potentially skew an average higher, leading to an inaccurate representation of gross sales. Another point is that whenever a franchisor discloses average gross sales and median gross sales, it must also disclose the highest and lowest numbers in the range. The point there is that inclusion of the highest and lowest numbers in the ranges containing average gross sales, gross sales information tells a more complete story about the performance of the franchisor. Another point is that one question that we had is how does this new rule, how does the proposed commentary, how does it jive with the current requirement that a franchisor disclose the number and percent of number and percent of outlets that actually attained or surpassed the stated result? Well, common sense seems to dictate that you wouldn't include the number and percent of outlets that attained or surpassed the median because that number is always going to be 50%, right?
Yeah, I think that's exactly right. So I think that examiners, while you're going to have kind of the percent and the number and percent of measured outlets if you have an average, I don't think you're going to have to put in numbers for the median.
So best performing outlets, we are using the terminology here, the phrase the yin and yang rule, because it helps to strike a balance. So the commentary provides that a franchisor may not include a subset of its best performing outlets in an FPR without also including the corresponding lowest performing outlets. This is going to be true even if the FPR also discloses system-wide performance information for all outlets. In sum, the rationale here is that is an FPR that is based solely on the performance of a subset of the franchisor's best performing outlets is likely to be misleading and accordingly have no reasonable basis.
Right. I had a situation last year where a client included averages for their whole system, but then included numbers for the top 5 and top 25.
Okay.
And the examiner came back and said you have to include the lowest 25 or the lowest 5, and so I discussed the issue with the client and we decided to just take those out. And so I think that's probably what's going to happen in some of these is you're going to make a decision, either you put in the bottom or the lowest performers, or you just end up taking out some of the top performing information.
Seems to make sense. So what about other subsets? Generally an FPR may be based on a subset of outlets if it has a reasonable basis, is accurate, and the information is not misleading. However, a franchisor with 10 or fewer outlets may not base an FPR on a subset of those outlets. Geographic subsets may be used as long as you provide an explanation as to why and how that particular subset was selected, and as long as the information is not misleading. The commentary also clarifies that a franchisor can leave out information from outlets that have closed during a period covered by an FPR as long as it also discloses the number of outlets that have been omitted. I think this is interesting because in practice, many franchisors likely already disclose that a certain number of closed outlets are excluded from the data presented. The change here is the added requirement that a franchisor actually identify how many of the excluded outlets closed within their first 12 months of operation.
Next topic we're going to cover is managed outlets. And the current proposed FPR commentary adds the concept of managed outlets. And it's important to understand what this new language covers because it's not necessarily intuitive, or at least it wasn't to me. When I think of a managed outlet, I think of outlets that are owned by a franchisee but managed by a franchisor or its affiliates. However, these outlets are actually included in the definition of operational franchise outlets in the FPR commentary. And so, bear with me, the managed outlet definition says it means any outlet that is owned by a person that's not a franchisee, the franchisor, an affiliate of the franchisor, or a person required to be identified in item 2, and is managed by the franchisor, an affiliate of the franchisor, or by a person required to be identified in item 2. That's a lot of words and something to sort through, but I think the key to understanding this issue and what this definition is determining whether the outlet being managed is owned by a franchisee or a non-franchisee. So in other words, if there's a franchise agreement in place with the owner of the outlet being managed, it's a franchise outlet. And if there's not a franchise agreement in place with the owner of the outlet being managed, then it's a managed outlet. And I think how this works is the owner actually doesn't have the right to use the trademarks, but it's actually the entity or the person that's managing the location that brings the right to use the marks. And apparently this is common in lodging and hotel industries. The good news is that you can include information about managed outlets in your FPRs, provided the data is not materially different from results of other outlets included in the FPR, and the franchisor discloses the existence of the managed outlets and identifies how they are characterized. So you can put them in the category of company-owned outlets or franchise outlets or even a separate category called managed outlets, but you just need to remember to at least call out the presence of these and how you've characterized them in the FPR.
Right. Let's talk about merged data. The rule of thumb here is that, excuse me, data from franchise outlets and company-owned outlets must be reported separately. There are two key exceptions. One is that a franchisor that separately discloses franchise outlets and company-owned outlets may present the same data in a combined format. The other is that a franchisor with a small number of franchisees may merge franchised and company-owned outlet data in their FPR as long as the gross sales between the outlets are not materially different. The presumption here is that a small number is 10, and the presumption is that a franchisor with 10 or more franchisees has an adequate or sufficient number to require the separate disclosure of data from both the franchise and company-owned outlets. It's interesting to note for this example that the second exception focuses on the number of total franchisees and not on the number of total outlets, rather. So I think this approach is reasonable because one franchisee can own multiple outlets. So the exception is focusing on whether the identity of a franchisee can be readily or easily ascertained.
So really at the heart of this, it's to protect the identity of franchisees. The idea being, unless you have a big enough number so that you can't tell which ones, that you should be able to merge them in that case to protect identity. Is that right?
Yeah, that makes a lot of sense, and that is correct. So limitations on the use of cost and expense data. The commentary adds footnote 6, and the footnote clearly establishes that a franchisor that includes gross sales alone in its FPR cannot provide a prospect outside of its FDD cost and expense information that would allow them to readily calculate net profit. I think an argument can be made that there may be some room for a franchisor to provide cost and expense information outside of an FPR that's short of net profits, like average labor costs or average rent, even if it only discloses gross sales in its FPR. However, it seems that NASAA and the FTC's position is that a franchisor that includes gross sales alone in its FPR is effectively prohibited from providing any cost and expense information outside of the FDD. So this is an interesting issue because typically those disclosures of cost and expense data occurs outside of the FDD. So the examiners are not aware of that that's happening. So whether this is actually going to be raised to the forefront would likely only happen if a dispute arises between a franchisee and a franchisor regarding the earnings claims and financial performance representation.
Yeah, and what's interesting about this one, this footnote shows up, but it's really meant to apply to gross sales of both franchise and company-owned outlets, like we've stated. And I know that there are franchisors that engage in a practice where they'll only provide gross sales in their FPR because they feel like they've got that information and they don't have as reliable information about cost. But then they'll rely on this exception to provide cost and expense information outside, and they'll give the prospective franchisee a blank pro forma and sort of helping them, fill in the information. And so what the FTC and what NASAA have said and what Dale has said is that they think that any information given outside of an FDD that allows you to get closer to net profits is prohibited. And so the question really is, what does it mean readily calculate average net profit? If I give you labor and rent, does that allow you to get all the way to net profit? I would say no, but again, really. I think NASAA's position and the FTC's position at least should give franchisors pause, and they should rethink a little bit about whether that information ought to find its way into, an FDD or if they're giving it outside the FTD, really being kind of cognizant of the position of the government.
Right. So we finally have some clarity with the admonition. A franchisor should use one of two forms of admonition, one for historical representation and one for projection. The commentary establishes once and for all specific requirements for ensuring that the admonition is in fact clear and conspicuous. The admonition must be presented in a separate paragraph, be in bold type. It may not contain capital letters or underlining or be in any larger type than the rest of the FPR. I think this is pretty clear. Note that the language of both types of the admonitions stated in the commentary apply to an FPR based on sales or earnings. If a franchisor is making an FPR based on outlet sales or earnings, so they must use that language without any variation and without adding any additional disclaimer language. If a franchisor is making an FPR, say, based on something other than outlet sales or earnings, maybe hotel occupancy rates, it may change the language of the sample admonition, but only to the extent necessary to actually fit the FPR. No disclaimers or waivers are in fact permitted. What's interesting here is that a franchisor may still provide ample explanation and should provide explanation for the data in its FPR. So it may be helpful to, what's interesting is a lot of franchisors include various types of disclaimers currently in their FDDs. And so it's going to be interesting to see whether, with the fact that explanations are in fact permitted, how you can sort of balance the two and provide sufficient explanation to forestall any franchisee disputes in the future.
Yeah, I think there is a fine line between a disclaimer and explanatory information, and lawyers are very good about, sort of making distinctions. And so I think you are going to be anticipated or expected to really kind of walk that fine line.
Yeah.
But I do think explanatory information can cut down on claims of misrepresentation, because if you provide all of the facts surrounding, especially historic, information as to what a franchise outlet has done or a company-owned outlet, I think you're less likely to say you were misled when you knew all the facts that were. So I would encourage folks to include explanatory information and to look at their disclaimers. One of the things that in doing this program for the ABA, we looked at all of the case law that's out there about FPRs, and there are just very few cases where the content of an FPR was at issue in the case. And what also turned is this required admonition was enough. I think lawyers like redundancy and want to have 5 disclaimers rather than 1, but the evidence of these cases suggests that 1 is just fine and that the required waiver or the required admonition does the trick. All right, we're going to focus just a second here on FPRs based on forecasts and projections. And the current proposed FPR commentary makes significant changes in this area. And I have not seen a lot of FPRs based on forecasts and projections, but my prediction is that we're going to see even less of them now, because I think that what has happened now is you've made these sort of all but obsolete. And so you now have to have, in order to do an FPR based on forecasts and projections, they have to be based on historical data and not mere hypothetical situations or expectations. And even more importantly, they have to be based on a reasonable sample of the historical results of the brand being offered and not on the results of other brands or on industry reports. And the FPRs I've seen of this type have really been more of like, you have an affiliate that maybe has a different brand, operates under different marks, and you want to use that information because it's going to be similar. You want to use information about a competitor. You want to look at industry reports, and I think this has, the change in the commentary has really, again, kind of, I think, led to probably the death of these kinds of FPRs.
Right. We'll have a memorial service for forecast and projections on Friday.
That's right. All right. Conclusion. So we decided we would divide the content into sort of easy issues and harder issues. So among the easy issues, these are things that you could do really easily this year to try and prevent any comments based on, an interpretation of the FPR commentary. So, for example, adding averages and medians where appropriate and the high-lows where you've got gross sales, including the required admonition in its proper form, eliminating top performer FPRs or adding in the lowest performers, and adding references to closed outlets, particularly those that closed within the last 12 months. The harder issues I see are ones where if you are making a gross profit or net profit FPR based on company-owned outlet data alone, you're going to have to spend some time really looking at that FPR and figuring out how you're going to incorporate the various supplements and adjustments. I think you're going to have to really make sure and look at that. And I think it's going to be harder if you don't have operational franchise outlets because you're going to have to make some predictions about what you think they're going to do. But that is going to be, I think, an area that's really scrutinized, and so I think you're going to have to look at that. I also think that going back to the disclaimers and explanations, I see when I look at FPRs that were done a long time ago and maybe haven't been looked at by examiners very closely, there are a lot of disclaimers thrown in there that may not be acceptable, I think, under kind of the new FPR commentary. And so I think franchisors ought to take a look at that language, and you're hesitant to cut back on those, but at the same time, I think you run the risk of getting comments even though you haven't on the same language in the past. All right, I think that is at least what we have as far as our program, and now we're going to see if we can work through a few questions.
So to the extent you have questions, remember to use the chat box to submit them. We're taking them now. We have had at least one question come in, so we're going to address that now. So the question here is, in separately disclosing the franchise outlets and company-owned outlets, is that accomplished in the item 20 table? The answer to that question is no. If you're making an FPR based on information from franchise outlets and company-owned outlets, that would have to be accomplished in item 19 in however you combine the data. So, for example, you probably will have a separate chart for the information on your franchise outlets and then a subsequent chart for information on your company-owned outlets. So that's achieved by actually including that information in item 19.
Right, and we call this out too, is once you combine, once you have included the data separately, then you could combine them, but in item 19, you still need to have separated out that data.
Right. So here's another question, Max. In disclosing outlets closed within the last 12 months, can that be accomplished by stating you are not including those that were not in the network the entire year being disclosed?
Well, originally we called these outlets, what I call them phantom outlets.
Yeah.
And the problem is if you're not ever required to disclose them and they were only open a year before they closed, you never really knew necessarily that they existed. And so even if you disclose those, you wouldn't necessarily know that they closed within 12 months. And so that's really the issue. And this was raised by some franchisee attorneys, because if there are a number of outlets that close and open within 1 year, that a prospect ought to know about that. And so that's what this number is getting at. And so I think you do need to make that specific disclosure that really goes beyond, I think, what franchisors do now.
Okay. Here's a juicy one. No forecast projections can be based on industry reports, but can industry data be presented without projection? For example, hotel industry occupancy rates. If by itself not an FPR, or can't they be included, can include in item 19, how can it be provided otherwise?
That's a good question.
Right.
I mean, you'd have to look at that particular item, but it is pretty limiting, I think, and one of the questions is, if it's not the same brand, I think it makes it's pretty clear that you have to have that brand. But again, you'd have to look at the specific language. But my understanding is that it's very much limiting on what you can use as far as what's in what you include.
And the question has been clarified to provide that this is for a new system with no history of operation.
Yeah, and I think this is the very reason why you can't include that information. Just going to see when it talks specifically about so it specifically says, must the historical data on which projections are based be data from the brand being offered? Mm-hmm. Yes, a projection must be based on a reasonable sample of the historic results of the brand offered to the prospective franchisee. The historic results must be from outlets substantially similar to the type of outlet offered in the franchise disclosure document. Projection may not be based on the results of other brands operated or licensed by the franchisor or its affiliates, or on the results of similar or competitive brands operated by others, or on industry reports.
Yeah.
So that seems fairly clear to me. This might be one where you may be able to work with examiners on what it means and whether you can include information. But I think this really has limited or will limit what those FPRs are going to look like.
Okay. Another question here is, how helpful are additional disclaimers in item 20? Is there a benefit to trying to sneak them past examiners? Do they really help shield franchisors from liability?
Well, let's hope no examiners are on the webcast. But again,
sorry, additional disclaimers in item 19.
Oh, in item 19. Yeah. Again, this is where I put this in the harder category. If you have disclaimers in there that wouldn't be approved now, do you leave them in because they may prove to be helpful? Again, I'm not sure they're necessary, but this discussion has come up on different occasions, and at least the examiners, they're looking for a fine line, or they are going to review, is it a disclaimer or is it really explanation that's helpful? And I think, again, there's going to be that fine line, and I'm guessing that some examiners are going to disagree on when you cross the line and when you don't. So, again, focusing on information that it's explanatory and sort of provides the background of the information, I think that's fine.
Right, right. So it looks like this is it for questions.
Okay.
So with that being said, we want to thank everyone for your patience and your time sitting in on our presentation today on the new proposed FPR commentary. We just want to remind you that The slides and an audio or a video of this presentation will be made available at some time in the very near future. Please remember that you can reach out to us via old-fashioned methods of contact. That would be phone, fax. Well, do we have fax machines still? Right. Phone or email. Even though I think Max did say he has a Snapchat or Instagram handle.
You can Snapchat my daughter and then tell her to ask your dad to call me. So that's the only way for me.
And please also remember to check out the webcast that we referenced. Please remember to you can revisit the 2017 franchise registration and renewal season webcast that we presented last month. And look out again for the invitation to the FDA menu labeling requirements webcast that we have coming up next month.
And I'd like to just say thanks again to all of you for joining us, and have a great rest of the afternoon.
Take care.